Chapter 3, Section 1, The Six Basic Principles. The Constitution of the United States dates from the latter part of the 18th century. It was written in 1787 and took effect in 1789. The fact that the Constitution is more than 200 years old does not mean, however, that now in the 21st century it is only an interesting historical artifact fit for museums and dusty shelves. It is instead a vitally important and vibrant document. The Constitution is this nation's fundamental law. It is by its own terms, quote, the supreme law of the land, end quote, the highest form of law in the United States. An outline of the Constitution. The Constitution sets out the basic principles upon which government in the United States was built and operates today. The document lays out the basic framework and procedures of our government and sets out the limits within which that government must conduct itself. The Constitution is a fairly brief document. Its little more than 7,000 words can be read in half an hour. You will find the text of the Constitution in your book on page 758. As you read it, think about the surprising fact that this brief document has successfully guided this nation through 2 centuries of tremendous growth and change. One of the Constitution's greatest strengths is that its words deal largely with matters of basic principle. Unlike most other constitutions, those of the 50 states and those of most other nations, the document is not weighed down with detailed and cumbersome provisions. As you read the Constitution, you will also see that it is organized in a simple and straightforward way. It begins with a short, noteworthy introduction, the preamble, and the balance of the original document is divided into 7 numbered sections called articles. The first 3 articles deal with the 3 branches of the national government: Congress, the presidency, and the federal court system. These articles outline the basic organization and powers of each branch and the methods by which the members of Congress, the president and vice president, and federal judges are chosen. Article 4 deals mostly with the place of the states in the American Union and with their relationship with the national government and with one another. Article 5 explains how formal amendments may be added to the document. Article 6 declares that the Constitution is the nation's supreme law. Finally, Article 7 states the requirements for ratification. The 7 articles of the original document are followed by 27 amendments, printed in the order in which they were adopted. The Constitution is built around 6 basic principles: popular sovereignty, limited government, separation of powers, checks and balances, judicial review, and federalism. In the United States, all political power resides in the people. The people are sovereign. They are the only source for any and all governmental power. Government can govern only with the consent of the governed. The principle of popular sovereignty, so boldly proclaimed by the Declaration of Independence, is woven throughout the Constitution. In its very opening words in the preamble, the Constitution declares, quote, "We, the people of the United States, do ordain and establish this Constitution for the United States of America," end quote. In essence, the national government draws its power from the people of the United States, and the people have given their government the power that it has through the Constitution. Similarly, each one of the state governments draws its authority from the people of that state through that state's constitution. Limited government. The principle of limited government holds that no government is all-powerful, that a government may do only those things that the people have given it the power to do. In effect, the principle of limited government is the other side of the coin of popular sovereignty. It is that principle stated the other way around. The people are the only source of any and all government's authority, and government has only that authority the people have given to it. The concept of limited government can be expressed another way. Government must obey the law. Stated this way, the principle is often called constitutionalism. That is, that government must be conducted according to constitutional principles. The concept of limited government is also described as the rule of law, which holds that government and its officers are always subject to, never above, the law. In large part, the Constitution is a statement of limited government. Much of it reads as clear prohibitions of power to the government. For example, notice the Constitution's guarantees of freedom of expression. Those great guarantees of freedom of religion, of speech, of press, of assembly, and of petition are vital to democratic government. They are set out in the First Amendment, which begins with the words, quote, "Congress shall make no law," end quote. Separation of powers. Recall the brief discussion of the parliamentary and presidential forms of government in Section 2 of Chapter 1. In a parliamentary system, the legislative, executive, and judicial powers of government are all gathered in the hands of a single agency. British government is a leading example. In a presidential system, these basic powers are distributed, separated, among three distinct and independent branches of the government. This concept is known as separation of powers. The first modern formulation of the doctrine of separation of powers was that of the French writer Charles de Montesquieu, who defined the principle of the separation of powers in The Spirit of Laws in 1734. Although John Locke had distinguished the legislative from the executive function of the government, he did not assign those functions to separate institutions. Montesquieu was the first to make the division among the legislative, executive, and judiciary. Arguing that the definition of tyranny is the concentration of all power in the same hands, he urged the division of the three functions of government among three separate institutions. Montesquieu's thinking profoundly influenced the framing of the Constitution of the United States. The Constitution distributes the powers of the national government among the Congress, or the legislative branch, the President, or the executive branch, and the courts, or the judicial branch. This separation of powers is clearly set forth in the opening words of each of the first three articles of the Constitution. Article 1, Section 1 declares, quote, "All legislative powers herein granted shall be vested in a Congress of the United States," end quote. Thus, Congress is the lawmaking branch of the national government. Article 2, Section 1 declares, quote, "The executive power shall be vested in a President of the United States of America," end quote. Thus, the President is given the law-executing, law-enforcing, law-administering powers of the national government. Article 3, Section 1 declares, quote, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish," end quote. Thus, the federal courts, and most importantly the Supreme Court, interpret and apply the laws of the United States in cases brought before them. Remember, the framers of the Constitution intended to create a stronger government for the United States, yet they also intended to limit the powers of that government. The doctrine of separation of powers was designated to that end. Defending this arrangement, James Madison wrote, quote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, may justly be pronounced the very definition of tyranny," end quote. From The Federalist, number 47. Checks and balances. The national government is organized around three separate branches. As you have just seen, the Constitution gives to each branch its own field of governmental authority: legislative, executive, and judicial. These three branches are not entirely separated nor completely independent of one another. Rather, they are tied together by a complex system of checks and balances. This means that each branch is subject to a number of constitutional checks or restraints by the other branches. In other words, each branch has certain powers with which it can check the operation of the other two. The Congress has the power to make law, but the President may veto or reject an act of Congress. In its turn, Congress can override a presidential veto by a two-thirds vote in each House. Congress can refuse to provide funds requested by the President, or the Senate may refuse to approve a treaty or an appointment made by the President. The President is the commander-in-chief of the armed forces, but Congress provides that military force, and so on. The system of checks and balances links the judicial branch to the legislative and the executive branches. The President has the power to name all federal judges. Each appointment, however, must be approved by a majority vote in the Senate. At the same time, the courts have the power to determine the constitutionality of acts of Congress and of presidential actions, and to strike down those they find unconstitutional. Head-on clashes between the branches do not often happen. The checks and balance system operates all the time, however, and in routine fashion. The very fact that it exists, that each branch has its several checks, affects much of what happens in Washington, D.C. For example, when the president picks someone to serve in some important office in the executive branch, as, say, Secretary of State or Director of the Central Intelligence Agency, the president is quite aware that the Senate must confirm that appointment. So the president is apt to pick someone who is very likely to be approved by the Senate. In a similar sense, when Congress makes law, it does so with a careful eye on both the president's veto power and the power of the courts to review its actions. Spectacular clashes, direct applications of the check and balance system, do sometimes occur, of course. The president does veto some acts of Congress. On rare occasion, Congress does override one of those vetoes. Similarly, the Senate can reject one of the president's appointees. And twice in our history, the House of Representatives has impeached or brought charges against a president, Andrew Johnson in 1868 and Bill Clinton in 1998, although on both occasions the president was acquitted by the Senate. But again, these and other direct confrontations are not common. Congress, the president, and even the courts try to avoid them. The check and balance system makes compromise necessary, and compromise is a vital part of a democratic government. Over time, the check and balance system has worked quite well. It has done what the framers intended it to do. It has prevented an unjust combination of the majority. At the same time, it has not very often forestalled a close working relationship between the executive and legislative branches. Note, however, that working relationship runs more smoothly when the president and a majority in both houses of Congress have been of the same political party. When the other party controls one or both houses, conflicts play a larger part than usual in that relationship. In fact, the American people have lately become accustomed to divided government, to a political environment in which one of the majority parties holds the presidency and the other party controls Congress. Since the Eisenhower era in the 1950s, one of the two major parties, most often the Republican Party, has usually occupied the White House, while the other party, regularly the Democratic Party, has had a firm grip on Capitol Hill. The now familiar pattern of divided government has had a marked effect on the conduct of business between the President and Congress. Much of the executive-legislative relationship has been rooted in partisanship in recent years. It has been much more difficult and much more confrontational over those years than it has been through most of the nation's history. Judicial review. One aspect of the principle of checks and balances is of such overriding importance in the American constitutional system that it stands by itself as one of the system's basic principles: judicial review. The power of judicial review is the power of courts to determine whether the government does what the government does is in accord with what the Constitution provides. More precisely, judicial review may be defined this way: it is the power of a court to determine the constitutionality of a governmental action. In part, then, judicial review is the power to declare unconstitutional, to declare illegal, null and void, of no force and effect, a governmental action found to violate some provision in the Constitution. The power of judicial review is held by all federal courts and by most state courts as well. The Constitution does not provide for judicial review in so many words, yet it seems clear that the framers intended that the federal courts, and in particular the Supreme Court, should have that power. In the Federalist No. 78, Alexander Hamilton wrote that, quote, independent judges, end quote, would prove to be, quote, an essential safeguard against the effects of occasional ill humors in society, end quote. In the Federalist No. 51, James Madison called the judicial power one of the auxiliary precautions against the possible dominance of one branch of government over another. In practice, the Supreme Court established the power of judicial review in the landmark case of Marbury v. Madison in 1803. We shall take a closer look at that case and the doctrine of judicial review later. Since Marbury, The Supreme Court and other federal and state courts have used the power in thousands of cases. For the most part, the courts have upheld challenged governmental actions. That is, in most cases in which the power of judicial review is exercised, the actions of government are found to be constitutional. That is not always the case. To date, the Supreme Court has decided some 150 cases in which it has found an act or some part of an act of Congress to be unconstitutional. It has struck down the several presidential and other executive branch actions as well. The court has also voided hundreds of actions of the states and their local governments, including more than 1,000 state laws. Federalism. As you know, the American governmental system is federal in form. The powers held by government are distributed on a territorial basis. The national government holds some of those powers, and others belong to the 50 states. The principle of federalism, the division of power among a central government and several regional governments, came to the Constitution out of both experience and necessity. In Philadelphia, the framers faced a number of difficult problems, not the least of them how to build a new, stronger, more effective national government while preserving the existing states and the concept of local self-government. The colonists had rebelled against the harsh rule of a powerful and distant central government. They had fought for the right to manage their local affairs without the meddling and dictation of the king and his ministers in far-off London. Surely they would not now agree to another such government. The framers found their solution in federalism. In short, they constructed the federal arrangement, with its division of powers, as a compromise. It was an alternative to the system of nearly independent states, loosely tied to one another in the weak Articles of Confederation, and a much feared, too powerful central government. We shall explore the federal system at length later in the course.